Okay, here we go.
Good afternoon. We're going to give everybody a few minutes to get in, and then we will get started. Good afternoon and welcome to the Public Interest Law Section's webinar on Residential Property Assessed Clean Energy Program, Florida, Problems and Concerns. Thank you for joining us today. We're very happy to have you here. This is presented in conjunction with the Consumer and Tenant Protection Committee, as well as Legal Services of North Florida. And many thanks to the Legal Services of North Florida for hosting this webinar and making it possible for us to be here today. We have three speakers who will be presenting on our webinar. First, we will hear from Laura Hughes. Laura is a senior financial investigator with the Florida Office of the Attorney General. She's been a certified fraud examiner since 2002 and has over 20 years of criminal and civil investigative experience. Laura has extensive experience with investigations relating to consumer lending, mortgage lending, and securities. We will also hear from Elena Mola. Ms. Mola is a corporate finance attorney. She's worked for Skadden Arps, Slate, Megger & Flom in the Project Finance and Energy Department, where she represented large financial institutions and multinational corporations in connection with a variety of transactions, including finance and energy. She's also served as an adjunct professor at Georgetown University Graduate School, where she taught international infrastructure development and finance. She has her JD from Georgetown and a Master of Public Administration from Georgia State University. Ms. Mola practices in South Florida and is a Florida licensed attorney. And lastly, we'll hear from Alice Vickers, who's a founding member of the Florida Alliance for Consumer Protection. Alice's career has been devoted to representing low-income consumers in housing and consumer issues through litigation and legislative advocacy. She was also with Legal Services for 28 years. Alice has been recognized as the Consumer Protection Lawyer of the Year, as well as the Consumer Advocate of the Year by the National Association of Consumer Advocates. My name is Laura Beckman, and I'm with the Public Interest Law Section, and we are very happy to have you join us today. I think you're going to enjoy the presentation that we have. In your webinar platform, you have the ability to ask questions. So along the bottom of the screen, if you move your cursor, it should pop up a dialog box for Q&A. If you post your questions there, we will be monitoring the questions throughout the webinar, but we do plan to save the questions for the end. We'll save about 5 minutes at the end to ask any questions, so please feel free to post them throughout. And we will also be sending out the information after the webinar on CLE credit, as well as the materials, the PowerPoint that you're going to see today, as well as a recording of the webinar so that you will have that for future reference as well. Before we get started, please notice the disclaimer at the bottom of the first slide on behalf of the presenters. And with no further ado, I will turn it over to Laura Hughes. Thank you very much.
Thank you, Laura. Well, you want to switch it? There we go. Okay, today we're going to discuss the residential PACE program in the state of Florida. Some of the issues that we're going to get into is I'll be doing an introduction of the program, give you an overview of how it works and what it's all about. We'll talk a little bit about statewide issues that have come up from complaints from consumers. They filed complaints both statewide and in the individual counties. And then Collier County had a recent experience with the PACE program down there, so Elena Mola is going to give you an overview of that. You'll get a little bit more in depth about the program and some of the problems and issues that came up in Collier County. And then Alice Vickers will be discussing PACE legislative and regulatory activity in Florida that's pending both at Florida and at the federal level. And as Laura mentioned, then we'll have a time for questions at the end. So the introduction to PACE financing. This is established under the Florida PACE Act, which is Section 163.08 Florida statutes. That's under the intergovernmental programs, and 163.08 is the supplemental authority for improvements on real property. Basically, what this program does is provides financing for qualifying green energy improvements through financing or refinancing, which is repaid through non-ad valorem special assessments that are added to the subject's property bill. Basically, what these improvements are is anything related to energy efficiency, energy generation, wind protection, roofing, so it includes solar, it includes windows, it includes air conditioning units, anything that's basically green energy. The assessment itself, what you're doing basically is you're authorizing a property tax obligation to be added to your tax roll on your property to pay for this improvement. So the assessment is attached to the property. It's not attached to the individual. This isn't something that's reported on the individual homeowner's credit report. It is attached to the property and it stays with the property. The program provides financing for both residential and commercial properties. We're primarily concerned in the state of Florida right now with residential. To give you an idea of the scope of the residential program for PACE, as of 2019, over 200,000 homeowners have made $5 billion in energy efficiency and other improvements to their home utilizing PACE financing. Now, commercial PACE financing is available largely throughout the country, but residential PACE financing is only available in California, Florida, and Missouri. The PACE program was first started back in 2008, and Florida passed the PACE enabling legislation in 2010. Some of the residential PACE programs in Florida that you'll see, if you see some, there's a lot of other programs as well, but a lot of them only do commercial. These are the main ones that are involved in residential. Alliance NRG program, the HERO program, which is administered by Renovate America, Renew PACE, which is administered by Renew Financial, Y Green Energy Fund, which is administered by Y Green. Basically, the program itself contracts with the individual municipality to offer the PACE program in that city or county. The administrator, Renovate, Renew, Y Green, they are national private companies that administer that individual program. So what they do is they approve the contractors in the county. They provide the applications and the paperwork. And then they work to provide the funding through the program and then present the paperwork to the county to put the tax assessment through. The county then is responsible for collecting the taxes and passing it back to pay back the financing. Basically, what the program does of how they raise the money is they issue bonds. They package and securitize these bonds, and they sell them. And that's how the funding continues to be made to the homeowners. I'll give you a little rundown of how it works. Basically, the homeowner contracts for a qualifying improvement, again, a green energy type improvement with a PACE-approved contractor. The contractor applies to the PACE program to become a qualified contractor. So each program has a list of contractors that they work with. In most cases, the homeowner is looking to make this improvement. They find a contractor, they call them, the contractor comes out and tells them about this program. That's usually the first time they hear about it. However, it's becoming a lot more popular in the state of Florida, and I personally have seen ads on television. I've seen them on my Facebook feed. We've gotten, people in my office have gotten mailers at home advertising this. So there is some instances where a homeowner may contact the administrator directly to find out about it and if they qualify, and in which case the administrator will refer them to an approved contractor. But most of the time, it's the contractor meeting with the homeowner and explaining the program. The contractor is the one that explains the program. The contractor is not a lender. They're not approved as a lender, as a loan officer. They're simply provided training by the administrator on what this program is and how to present it to the homeowner. Usually it's an online training from what I've seen. Some of them may have people that go out and help to train these contractors on what the program is. So the contractor then is provided by the administrator the paperwork electronically. So it's either on, say, their tablet or their smartphone. So they will present that to the homeowner, all the documents that need to be signed, and they will be signed using DocuSign, where they just click the button, hit the initials, and then click it to have an electronic signature at the end. That then uploads to the administrator, who looks at the information and basically determines the amount of financing that's available. And the amount of financing that's available is based on the equity in the property. Again, as I said previously, this isn't attached to the individual. So it doesn't take into account their income, their credit quality, anything. It's just a matter of what percent of equity do you have in your home that can be used to finance this project. There is a 3-day right of rescission. So what happens then is the administrator will report back to the contractor and say, yes, this homeowner is approved, and here's how much they're approved for, the maximum amount. So then, at some point in time, and I can't say exactly when because it's up to the administrator of what they do, that the administrator may have a welcome call where they call the homeowner and they go over the terms of this financing to make sure that they understand it. Hopefully that happens within the 3-day right of rescission period. But again, the individual administrator is the one that sets up their program and how it works. So I can't say for sure how and when that happens or if it does at all times. So once the program administrator sends back the amount that's available, it authorizes the work for the contractor to start. Upon completion, the contractor will send a certificate of completion up to the administrator, who will then authorize funding back to the contractor. I've seen mostly the payments going directly to the contractor, but I believe it should be that the funding goes back to the homeowner, who then pays the contractor. But there is paperwork in there that allows the contractor to be paid directly, that the homeowner authorizes them to be paid directly. So the administrator, once the work is completed, will automatically pay the contractor for the amount due. And then in the background after that, the financing statements are filed with the county, the special assessments are added, and then at some point in time in the future, additional taxes will be due on that property to offset the financing. Some of the complaints and issues that have come up. Again, the terms of the loan and the paperwork can be very confusing to individuals. Because this isn't a traditional credit application, they're not giving their income, they're not saying where they work, all these things that make you realize, I'm borrowing money here. That doesn't happen. So some of them just don't really have a clear understanding that this is a loan, basically. And also because the contractor is presenting it, they may or may not explain it clearly. And we've seen some instances where they misrepresent it as a government program or make it sound more like it's a grant or some type of a program to help with energy efficiency that's offered by the government. And because you're also not paying any money up front, the homeowner will walk away not really clearly understanding what this is and how it has to be paid back. The contractors are not affiliated with the program. They're simply approved to sell the program by that individual program. You know, they check the licensing, make sure they're licensed, and hopefully do enough due diligence to make sure that these are good contractors. But again, that's up to the individual administrative company to do that. Again, there's no income qualifications, there's no credit reporting, so the ability to repay is basically not there. I mean, I guess you could argue and say, well, the ability to repay is the fact that you have enough equity in your house, and if you can't afford to pay your taxes, you can sell your house. You know, my argument would be that offsets the purpose of doing this green energy upgrade. But people don't understand that when they add $2,000 or $3,000 a year to their tax bill, they have to put that money aside every single month, and they need to have the ability to do that. And they're not necessarily understanding or planning for that. There's no oversight on the quality or the completion of work. Unlike a traditional lender that's concerned with, the value of the property after this improvement, and they make sure it's done, they make sure it's done right because they have to protect their investment. This is different because it's simply being added as a tax obligation. So the lender and the tax obligation takes first priority lien over the mortgage. So these are very, very low risk loans. If the tax doesn't get paid, a tax certificate gets sold to an investor. The investor pays the taxes, and then after a waiting period, it goes into a tax foreclosure sale. So the company funding the project is really at a very low risk position. So the oversight of the quality, the completion of work, it doesn't matter as much in this case to them as it does in a traditional lending situation. When you look at the loans, they do have fees and costs. The underwriting and administrative fees, they can be in excess of 5%. In some of the smaller loans, I've seen them 10% or more in underwriting administrative fees. And then the unique thing on this financing is the capitalized interest. Because you are, say you do your project in February, your taxes are not going to be due until the following year. So there's no way to make that payment today. So what they do is they capitalize the interest up until the first payment, and then they add it to the principal balance. Some of these, and I've actually seen advertising that says that they can delay it up to 29 months. So basically what they will do is calculate the interest for 29 months, add it to your principal balance, and then amortize that over 20 years. That can add 5 to 15% to the loan amount as well. So just to give you an example of one, I rounded the numbers just to make it easy. Say you get an air conditioner for $13,000. And I have seen air conditioners for $13,000. And the administrative costs and underwriting fees are $900. The capitalized interest, it came out at $2,300. So now your $13,000 air conditioner, you are going to have a principal balance of $16,200 at 7.25% for 20 years. So your annual payback is going to be $1,500 a year in taxes, and your total payment after 20 years will be $30,000 on your $13,000 air conditioner. So again, it's not always clear to homeowners how much these costs and fees and capitalized interest can add up to what you are ultimately paying in the end. And then, as I mentioned previously, the tax assessment has priority over any other liens on the property, including the mortgage. That has issues. The mortgage industry obviously has a big issue with this. The homeowner is supposed to notify the mortgage company prior to it being approved, but it's the homeowner's responsibility, the way that it's been structured. So the homeowner necessarily doesn't understand that. They don't do it. It just doesn't make any sense to them. So seeing a lot of instances where that's not happening, that the underlying mortgage company knows nothing about this, and now they've lost their priority lien on the property. That's changing, and we'll talk a little bit more about that as we go forward, but that issue is changing somewhat. Other things is, in the underlying mortgage, if you have an escrow account, you need to notify the mortgage company so that they can add enough to cover this additional tax payment into your escrow account. Again, some people don't understand just how much that might add, and if there's suddenly, $150 a month more on their mortgage payment and they can't afford that, it could potentially throw them over into foreclosure on the mortgage side. The sale of the property, these loans are presented as the lien stays with the property. You sell the property, it stays with the property. And that is true, it does. However, mortgage companies a lot of times will not write mortgages, including the PACE lien. so therefore they have to be paid off in order to sell. There's issues with FHA and HUD in insuring loans that have these kind of liens. So that the mortgage companies and the selling of the home is not as clear as it may appear on the surface. Some counties have put in additional protections. I know Broward has, and a couple others that they've taken it upon themselves within the county to add additional protections. Collier County is one that particularly got very in-depth on this issue and was working on putting additional protections in place. And I think Elena's going to be able to take some time to go a little bit more into detail and get more in-depth on what happened down in Collier County.
Thank you, Laura. I am going to speak to the Collier County PACE experience, the research that was done here, the analysis, and the eventual termination of the residential PACE program. What ended up happening here is, I think what's happening everywhere, is that PACE is catching the counties and the homeowners by surprise when they in fact start looking at the effects and the details of PACE. So I'm just going to go quickly through a couple of things, especially Florida PACE statute, which Laura did, but I just wanted to make a couple of additional emphasis. The PACE financing can only apply to qualifying improvements. Those improvements have to be affixed to the property, okay? One issue that we were looking at and we saw in Collier County is that in these PACE financing agreements, contractors who would sell, let's say, a new air conditioning, and along with that air conditioning would sell a maintenance agreement for that air conditioning, whether it was $500 or $600 or $1,000, and it went into that PACE financing. That is in violation of the state statute. So when qualifying improvement, it has to be affixed to the property, okay? All the property assessments, the property, I'm gonna go back. Every single provision in the PACE statutes are geared towards protecting the PACE lender. So you will see that the property, the taxes and the assessments on the property can't be delinquent. There can't be any voluntary liens on the property, but that doesn't mean that when you look at the county records, the individual homeowner may have significant credit issues, but as long as they are not related to the property, then the financing, the PACE financer or lender can go ahead and put a lien or enter into financing with that homeowner. Two things I wanted to mention. The issue of the total amount of the PACE assessment or the PACE financing cannot exceed 20% of the just value of the property. That's what the statute says, as determined by the county property appraiser. And the property appraisers in the county only make two determinations: the assessed value and the fair market value, okay? The PACE lenders here have created, in some cases, their own determination of what is just the 20% of the just value or the just value of the property, which has nothing to do with the determination or any determination that the county appraiser makes. So do we look at the assessed value of the property or the fair market value to determine if, in fact, they have abided by state law? There are a couple of exemptions to that, and we can get into that later. So supposedly there's the ability of each county to add additional requirements through standard agreements with the county, and then the tax collector has the ability to add additional requirements to these PACE loans. But they're negotiated by the PACE lenders on an individual basis. So there is no standard throughout the state of Florida on consumer protections for this PACE statute. And if, for example, one PACE lender will agree to something, whether it's in California on, for example, looking at the homeowner's ability to repay the loan, or may look at other requirements for consumer protections, let's say in Sarasota or in Broward County, they can decide that they might be able to get away with not providing those consumer protections in Collier, so they won't do it. And so that becomes a problem when they're advertising their product throughout the state, but each separate county has different consumer protection standards. For example, in Collier County, the standard on agreement said that the PACE provider or lender had to provide optional assistance to those who may have difficult reading or understanding the PACE materials of the financing agreement, including providing notice of such option and assistance in English, Spanish, and Creole. The other thing that Collier County required was that the PACE provider be solely responsible for all matters associated with origination, funding, financing, administration of tax assessments, complaints, inquiries, assessment, qualifying improvements, or any other aspect of the program. And then it said that the PACE provider was to ensure that its agents, presumably their contractors, administrators, subcontractors, are at all times in compliance with the terms of not only the county standard agreement, the applicable county, Florida, state, and federal laws. Now, you would think that that would be broad enough and strong enough to provide some sort of consumer protections. Well, it isn't, because if it's in an ordinance and there is absolutely no way to either audit each of these loans to see if there was compliance, it is very difficult to enforce. So when we go back here and it said, what are the other applicable, let's say Florida statute or federal laws? We already said that, well, at least in my opinion, Florida state statute, PACE statute, really has absolutely no consumer protection, but there are some other laws that may be applicable. One of the laws that is pending rulemaking at the Consumer Financial Protection Bureau is there were senators that were very worried about what was happening in California with the PACE financing. It was specifically alleged that the PACE lenders, all three of them are the same PACE lenders that came from California to Florida, so they're private companies, that they were basically engaging either directly or through their contractors in deceit, misrepresentation, and in fraudulent activity in connection with procuring some of these PACE loans. So both California and at the federal level, there was a lot of work done to enact legislation for consumer protection, especially with respect to PACE financings. Senator Rubio and Senator Cotton, along with a couple of California representatives, put together what they originally called the PACE Consumer Protection Act. That was then subsumed by the Economic Growth, Regulatory Relief, and Consumer Protection Act of 2018. And what it did was to amend the Federal Truth in Lending Act to require the applicability of the ability to repay standards to PACE loans, okay? i.e., if you are a PACE lender, you have the obligation to determine whether a homeowner can actually repay the loan before you sign them up and you put a tax lien on their home. Now, what has happened? The statute was enacted, but the Congress sent it up to the Consumer Financial Protection Bureau to enact rules. What are the standards or what methodology is going to be used to determine the ability to repay? Now, there is some issue as to whether, and in California state enacted a statute which required additional consumer protections, one of which was ability to repay standard. After California did that, the percentage of PACE loans decreased significantly. So the volume of business for these companies went down significantly. What has happened is that the companies have turned their attention to Florida. And what you see based on the bond issuances in Wall Street for these PACE secured bonds that are issued by the same PACE lenders or affiliates is that the percentage of the securitizations are now 70% based on Florida residences and about 30% California. And that happened, in my opinion, simply because California put in stronger consumer protections for these PACE lenders, especially ability to repay. All right. The CFPB has yet to issue final rulemaking on what methodology or what additional standards would be applicable to PACE loans. This is providing, in my opinion, a problem, because every week that goes by that these PACE lenders are signing up Florida homeowners, it's an additional 100 or so tax liens on these homes to people who may not have the ability to repay. And so the question is, do they, given that there is the act is already in place, have at least, whether maybe not a legal responsibility, but even a moral responsibility to even determine ability to repay? The PACE lenders say they don't have that obligation, at least not in Florida. Even though they have it in California and they have the methodology in California, they refuse to apply it in Florida. The other applicable statute that I think may be applicable to these PACE residentials is the e-Sign Act, which requires information pertaining to consent, including information about the option to receive card copies, to be clear and conspicuous. As Laura mentioned, most of these loans or financings are procured by the contractor, basically acting as the de facto representative of the PACE lender sorry, that's not me, but anyway, with the homeowners. They come with either an iPhone or a mobile tablet, and ask the homeowners, explain, sometimes well and sometimes poorly, what this financing is all about. Sometimes they tell them that there is, in fact, a tax lien. Sometimes they don't. Sometimes the people can't even speak English and sign up on these DocuSign on an iPhone or an iPad. Then the other applicable statute that may be applicable is the Florida Deceptive and Unfair Trade Practices Act, and then Florida Statute Chapter 117 with respect to notarizations. Notice of commencements, at least in Collier County, are required to be notarized. And over we find that the contractors themselves are basically explaining these notice of commencements to the homeowners, sometimes just saying this is the form to initiate the process. instead of saying, this is the notice that gives me the authority to go ahead and start your home improvement. And the contractors themselves notarize those notice of commencements. So in Collier County, what happened was the program started in October of 2017, approximately. In March of 2018, in March of 2019, all of a sudden people start getting their tax bills, and what they find is they have this tax bill that went up, by 100, 200%, sometimes 500, sometimes 2,000%. They couldn't figure out why. So then they went to the tax collector and the county and realized that they had this tax assessment that was actually a tax lien, and they, in their mind, had only signed up for a contractor to put in a roof and had no idea that they were signing up for a tax lien. So it was causing so much confusion that the clerk of court started an investigation. I started doing an investigation, and the clerk of court got involved. And these were our findings. Just the first year of PACE was the findings. 127 PACE property tax liens with an average financing term of 17 and a half years. The average tax increase just due to that PACE assessment was on average 117.7%, or $2,598 more. 68% of the PACE tax liens were concentrated in 2 zip codes, which are the poorest or least advantaged homeowners' zip codes. 24 of the 102 PACE liens were sold or financings to Habitat for Humanity homeowners, all clustered again in those same zip codes and some in Immokalee. 70% of the 50 PACE financed solar power systems were in homes with market values of $250,000 or less, also located in those same zip codes. 42.5% of those total PACE assessments exceeded 20% of the fair market value of the property as determined by the county tax appraisers. Again, the PACE lenders will say, it says just value. And so in their mind, in some cases, they develop their own assessment of what the value, the just value of the property is, but they forget the additional provision in the state statute that says it's determined by the county tax appraiser. Again, 42.5%. This is what we're seeing. 69.2% of the PACE loans were for HVAC systems that had 20-year terms. Now, most air conditionings, at least I haven't seen one air conditioning that's guaranteed for more than 10 years. So these people are going to be paying for their air conditioning system for 20 years after the air conditioning is already out of warranty and may not be working after 10 years. And so initially they said no, they would never guarantee, have a term for air conditionings of more than 10 years. And then all of a sudden we're finding 20-year terms on these air conditionings. 49.2% of the PACE financing agreements were not recorded within the 5 days of execution. Again, in violation of the statute. Only 4.1% of PACE loans were in compliance with the 30-day notice requirement to lenders prior to entering through a financing agreement. And though in the little small print, it says that the property owner is required to notify the lender. They have 30 days to do it. Well, if the property owners have 30 days to notify their current lenders. Hold on, where is it? And they only have 3 days to cancel their financing. It's very hard, and most of the homeowners either didn't comply. The other thing is they were supposed to provide copies to the PACE lenders within those 30 days. Well, the PACE lenders didn't get it, but again, it's meaningless because all the onus is on the homeowner. 66.4% of PACE projects undertaken by 3 PACE contractors in Collier County. Those three PACE contractors are supposed to be, well, all PACE contractors, the lenders say, are supposed to be vetted, authorized, and certified. I mean, if you're a homeowner and you want to use your local contractor that you know has a good reputation, you're not allowed to do that. You have to use one of the PACE authorized, certified, and vetted PACE contractors. In Collier County, 66.4% of all PACE projects were undertaken by 3 PACE contractors. Every single one of those is under criminal, civil investigation, or has been suspended. And I can tell you the one that was suspended, who dissolved both of the companies that he was working under, has now already reorganized under different company names and is operating up in Tampa as a certified PACE contractor with another PACE provider who knew that this contractor was suspended because they were at the hearings here in Collier County. That's what's happening. PACE contractor notice of commencements, again, as I say, were notarized by contractors, and some of those had obviously apparent forged signatures, again, in violation of Florida statutes. PACE program lenders and contractors continue to market themselves as a Florida government program. When they are marketing themselves as a Florida government program or a county government authorized program, and you go into these poorer neighborhoods, people assume that you're telling the truth. Yes, they're a government program. And that creates a problem because people trust them and they just sign anything they put in front of them. In addition to the work that the information that I just provided that was in the investigation audit done by Collier County, I just wanted to bring out a couple of additional findings that I had. I found that the PACE providers and contractors conducted into a pattern of conduct which disproportionately affected vulnerable homeowners, mostly seniors, disabled vets, economically disadvantaged, and non-English speakers. And I'm just giving you 3 examples, okay, where property tax increases due to the PACE assessments were as high as 2,327%. And why? In Florida, we provide, here in Collier County, additional tax benefits, property tax benefits for those categories, widowed, service seniors. And we had 2 seniors, disabled vets, whose property taxes were $213 a year. They signed these agreements, and I can tell you none of them, because I've spoken to all of these people that I'm mentioning, ever knew or understood that they were signing a tax lien or exactly what the financial conditions were going to be of their loans. And you can see what the increase. They went from $213 a year to $4,177 and $5,076. Here's a Habitat for Humanity homeowner, $724. The PACE assessment, $5,413. Now they're having to pay $6,137 a year. And we're talking $6,137 a year for 20 and 30 years, okay? For homes that are worth usually somewhere between $180,000 to $250,000. Of the 127 of the 129 notice of commencements filed by PACE solar contractors here in Collier County, again, they were located in Golden Gate City and Naples Manors, the poorest sections of town, in addition to Immokalee. They were associated mostly with Hispanic and Haitian homeowners with values of $250,000 or less, 1,500 square feet, average electricity bills of $150. 70% Hispanic or Latino, 11,000 per capita income, 26.5% below the poverty line, 13% of those 65 and over. Golden Gate City, 61% Hispanic or Latino, over 50% foreign-born non-native English speakers, per capita income, 19,000, 14.1% under the poverty line, 10% of those, 65% or over. Now, here is some of the initial research that I did. You can see service disabled, senior, widowered, what neighborhoods that they live in, okay? The PACE tax, the county tax that they were paying, total tax, and here are the increases in their taxes. And this is, again, for 20, 30-year terms, okay? Anywhere from 2,327 to 216. They're marketed as a government program. They're still being marketed even though here in Collier County, even though they were terminated. So here it is, county approved program, Florida County approved program, state of Florida government approved. Even the Florida PACE Funding Agency, it says, the Florida PACE Funding Agency was created in 2011 through an interlocal agreement between Flagler County and the city of Kissimmee for the sole purposes of leveraging, again, anytime that you have people coming at you, especially after Hurricane Irma, which is what happened here in Collier, it's a government program. We're here to help you. It's approved by your local government. You pay to your local government. And in back, what you really have are private for-profit companies that are coming in from California. There are administering entities that are recognized under Florida law as local government entities. You've got a problem because people tend to trust that they are actually government entities, but they're actually for-profit companies. So, for example, the Y-Green Green Corridor. Y-Green Green Corridor, everybody assumes is a local government entity, and it's treated as a local, recognized local locality, government locality, okay? The administrator is Y-Green. Every single employee is a Y-Green employee. But this green corridor was negotiated between, and the terms and how it functions, between Y-Green Fund and the Township of Cutler Bay. They created this green corridor PACE district. What happens? Then once this locality, this green corridor district, PACE district as locality is formed, then Broward signs up to it, Collier County signs up to it, and everybody assumes it, just gives it a cloak of, hey, this is a government program. Anyway, I'm running out of time. I'm going to run through this. What happens when these contractors come, okay, to the homeowners? Now, remember what percentage I told you were non-English speakers, what percentage I told you were seniors, you know, in these two areas in Collier County, okay? And remember, the Collier County specifically required that these PACE lenders provide them with the option of having the documents and all of the financing agreement explained to them in their language of origin. I have found only two financing agreements of these that we analyzed that were in Spanish. And I have found people who signed financing agreements in English who could not read, write, or speak English, or one who couldn't even read or write in Spanish and signed her name with an X. But the document is signed in English, the notice of commencement is signed in English, and there was a digitally created signature for this particular homeowner in these docu-signed Y-Green financings. So this is what you see when the contractor comes. Again, the contractor is the one that supposedly explains all the terms and conditions to you. 22 pages. In those 22 pages, you have a notice of rights and responsibilities and homeowners' representations and warrants. When you look at that, it says that the homeowner indemnifies Y-Green. The homeowner has 3 days to rescind the contract, and on and on and on. But that's kind of what they're seeing. So seniors are signing up to this, non-English speakers, people who are disadvantaged, anyway. So what do the PACE providers say? Hey, we're not responsible for the contractors. We, even though they supposedly vet them, authorize and certify them, and they're the ones that are basically acting as these de facto sellers of this financing, the PACE lenders say we're not responsible for contractors. We get rid of them once we find out they do something bad, right? Where we come in to make sure that there's consumer protections is our confirmation of terms call. So once we get this signed DocuSign document from the contractor, remember the homeowners never see this. We call them, or we have a confirmation of terms calls, and they specifically say that in this confirmation of terms calls, what they do is go through the document in detail, all the financing agreements and everything. So we were able to get a transcript of an actual confirmation of terms calls, okay? It lasted 10 minutes and 10 seconds, okay? And what you will find in this confirmation of terms calls is that the Y-Green confirmation of terms representatives basically discloses that the total financing in this case was $8,482. The special tax assessment is to be paid to the county. And then it says PACE is not a free government program, and Y-Green nor the contractor or governmental agencies, blah, 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 okay? The homeowner, when the contractor came to him, he says that the contractor quoted him $5,000 to fix his roof, plus zero to very little interest under a government program. The homeowner was unaware that the total PACE financing lien recorded on his home was $12,260. The PACE confirmation of terms call representative neither mentioned nor explained that a tax lien would be placed on his home to secure the PACE financing, and never told the homeowner that the total financing, the total amount he would have to pay was $12,260. He only said $8,000. So if that's the standard under which we are allowing these companies to basically record a first priority tax liens on these homes for these individuals for 20 or 30 years, we've got a problem. For that, I'm going to turn it over to Alice.
Thank you, Elena. And my cat was so excited by that presentation and such great concern that she was screaming out there.
Sorry.
No problem. Thank you so much. I learned so much throughout that presentation. Our organization has been working on this issue since about October of 2016. And I will say that this is the Public Interest Law Section's second webinar on this issue. So it is something that is of great concern to those of us who advocate for consumers. We are very excited that Representative Zika and Senator Hooper, both from the Pasco County area of Florida, have filed bills to create some consumer protections within 163.08, which both Laura and Elena explained to you, and so carefully showed how they are lacking in consumer protections right now. So next slide. So some of what the bill does is it does create an ability to repay determination. And as Elena explained, there has been federal legislation that has directed the CFPB to create rules that will create an ability to repay determination. The CFPB did solicit comments through the Federal Register. They were open to anyone to comment about concerns that they were seeing with the PACE program. Our organization did file comments with the help of both Elena and Lynn Drysdale, and there has been no action since the closing of that comment period. So that's one of the reasons we turned to the state to look for an ability to repay determination. We don't know when or if we will be getting that kind of support at the federal level. It also removes the super lien status of the PACE loan. I believe Elena touched on that. These PACE loans do take precedence over the home mortgage and any other lien on the property. So this would revise those provisions and create some changes to that, so there would not be the super lien status, which from the consumer's perspective is very important, because what we are seeing is homeowners who later would like to refinance or sell their homes, and Fannie Mae and Freddie Mac, FHA, they are not allowing that to take place if you have a PACE loan on the property. So it's an important concern for consumers. Elena explained carefully the concern about the improvements being paid beyond certainly the warranty of the fixture, but additionally probably the life of the fixture. And so this would put a limitation on loans not exceeding the life of the improvement. It would limit the amount of the loan as a percentage of the assessed value of the property. It would provide a right to cancel the contract, and it would provide a private right of action for violation of the provisions. One important note that I just want to call out real fast is data collection. We are so fortunate to have had Elena Mola in Collier County collecting the data that she shared with you today. Otherwise, we have no data that's letting us know what is happening throughout the state of Florida with these loans. Some sort of statutorily required data collection would be very important in learning what is happening with the loans here in Florida. And so the last panel just gives you some of the contact information for some of the those that would be involved with this legislation. And with that, I will close.
Great. Thank you, Alice and Laura and Elena. We do have a couple questions. Laura, the first one is for you. Can you explain what an administrator is and who employs her?
The administrator is the company that runs the particular program. So when we refer back to my slide, the HERO program is a program that's set up in Florida. A company out of California called Renovate America, and as Elena explained, these are for-profit corporations. They're the ones that administer the program. It would be similar to, that would be the bank, if you will, that they provide all of the paperwork, they approve the contractors, they do all the administrative functioning to provide the funding through the HERO program.
Thank you. Elena, I think the next one is for you. So hypothetical, if we had a PACE homeowner who has an agreement which states her tax first payment date will be March 1st of 2020. However, the tax collector included this PACE payment in the 2019 taxes due, and the client's lender paid it. Is this demand for payment in advance of the due date appropriate?
The way it usually works is that it's the PACE administrator who sends the tax collector a list of the homeowner or the property and how much they have to collect. The tax collector doesn't just willy-nilly bill people. It's the PACE lender who has to give the tax collector the information. So if in that case, if they have an agreement that says the PACE loan or the payment is not due until so many months later, then they need to go back to the PACE lender.
Okay, even though in this situation it sounds like the lender has already paid it, and I'm assuming tacked it on to the mortgage.
Oh, you're talking, no, I'm talking about the PACE lender. Okay.
Right, so in this hypothetical, the first payment was not due until March of 2020, right. But it looks like the PACE lender sent the information to the tax collector, and the tax collector added it to the 2019 taxes. Right. Which the lender then paid.
Yeah. So, I mean, if I were them, what I would do is I would go back to the PACE lender and say, hey, you incorrectly or against the terms of our agreement billed me prior to when you were supposed to, and determine whether there's some adjustment that can be made, because the tax collector is only acting as a collector for the PACE lender. So maybe, I don't know how they would work it out, but maybe the money can be refunded or something.
Right.
This is Laura. That's an interesting question, because I have seen that when I talked about how some of these, they say that they'll push them out as far as 29 months, but then the financing statement has to be filed with the county, that the homeowner has to be astute enough to be able to know, are they really pushing it off to 29 months? And to be honest, when the taxes first came out this fall, I went through to look at some of those to see what the homeowner would, best thing to do is go back to the paperwork and look at the amortization schedule that was provided. Because if that was capitalized and added to the principal balance, but now it's being charged early, then they'd be overpaying.
Yes.
And it sounds like it's just another example of how complicated these can be.
Well,
yes, exactly.
And the truth of the matter is, when I've asked some of these homeowners for their PACE financing agreements, they don't have them. They have to go back to Y-Green, whomever, to have them digitally, send them via email. Because one of the things that they agree to when they sign up for these loans or these financings with the contract, when the contract comes, is the requirement that all of the documentation be provided and executed digitally. So they don't have even a written financing agreement or any written documents unless they specifically ask for it and they themselves print it.
Okay, thank you. Those are all the questions that we have, and we are out of time. So thank you again to everyone for attending. Following the program, we will be sending out an email with the CLE information, as well as a copy of the recording of this webinar and the materials that you saw today. A special thank you to our three presenters, and all of your knowledge was very helpful and very enlightening. And thank you again to Legal Services of North Florida for hosting this webinar. And please stay tuned for more webinars from the Public Interest Law section. If you are not already a member of the section, we strongly encourage you to join. We would love to have you. Thank you very much and have a great day.